Justice Gorsuch?
I'd like to follow up on Justice Kagan's question, General. Under State Farm, one of the things that the government must normally do is, in its memoranda, explain not just the benefits of its proposed course of action, but also grapple with the costs or negative effects of a program that it proposes. And your friends on the other side argue that that's another deficiency in the Secretary's memorandum, and I'd like to give you the chance to respond to that.
Yes, of course. So I want to say at the outset that my friends are mistaken to suggest that the Secretary didn't even consider costs here. The Department extensively modeled the costs associated with this program and submitted those cost estimates to OMB.
I don't just mean the numbers, but generally the negative effects to the economy, to other persons, to people who don't have this opportunity for debt relief. There are a variety of factors that under State Farm normally the government would have to consider, and your friends on the other side argue those are not present in this memorandum.
Well, I think that those were certainly part and parcel of the Secretary's determination about how to tailor this relief. The Secretary recognized that the central purpose of the HEROES Act was implicated here because there were going to be millions and millions of student loan borrowers who were at serious risk of default and who were in a worse position because of the pandemic. But then he decided to tailor the plan to look at those particular risks and decide on the scope of relief to offer those borrowers. And of course, the costs associated with that are the flip side of providing HEROES Act relief in any circumstance. There are always going to be the cost to the government of offering that benefit to borrowers.
Again, not just the cost to the government. I'm sorry to interrupt, but what I think they argue that is missing is cost to other persons in terms of fairness, for example, people who've paid their loans, people who don't have planned their lives around not seeking loans, and people who are not eligible for loans in the first place, and that $500 billion is being diverted to one group of favored persons over others. I think that's the nature of their argument, in addition to, as you point out, the cost to the fisc. And I didn't see anything in the memorandum that dealt with those kinds of questions. And if there is something, I'd be appreciative if you could point me to it.
No, there's not, but that's because I think that those kinds of arguments are inconsistent with the statutory scheme that Congress set up here. Congress already made the judgment that in the context of a national emergency, you should be able to provide borrowers with this kind of relief to serve this purpose. And so I think for the states to suggest that it's incumbent on the Secretary to say, actually, I'm not going to do that, even though Congress wanted me to ensure that borrowers won't be left worse off, is just at war with the whole statutory purpose.
I appreciate that. Congress has given the executive branch a lot of emergency authority, and I think your argument rests on that. But it also requires generally the president to specify the provisions of law under which he proposes that he or others will act. That's 50 U.S.C. 1631, I think. My notes are right. And I'm just wondering, did that happen here?
Yes, it did. So the COVID-19 emergency, the specific provisions that he invoked were part of the Social Security Act and HHS's authority to target the spread of disease. I can't give you the exact citation here, but that determination was made.
Did he indicate anything under the HEROES Act or the Department of Education that's acting in this case?
No, but I think that it's clear that the HEROES Act is linked to the declaration of the national emergency, not the other way around.
Okay. And then finally, on standing, in the New York census case, the majority of this court held that the failure to count an individual, potential failure to count an individual, undercount the census, would have potential effects to the state of New York in terms of the benefits it might later receive. That kind of knock-on effect was sufficient to constitute standing in that case. And I'd just like to get your thoughts on how you'd have us distinguish that.
Sure. So in that case, of course, the court was looking at a census count that was going to plug in directly to the amount of federal funding that the state would receive. And I think that, you know, in the kind of terminology that we've been using and thinking about this issue with, that was a direct effect, that effectively the action would, by virtue of determining federal funding for the state, in that way operate directly on the state or at least determine its rights and interests. And here, there's not the same kind of direct effect. Of course, as I've already mentioned to Justice Sotomayor. We think that this is a self-inflicted injury to begin with, so the court doesn't need to get into those issues. But even if it does, here, the kind of downstream effects on tax revenues bring this case within Florida versus Mellon as the closest analog and not Department of Commerce.
Thank you.
Justice Gorsuch?
I understood the Office of Legal Counsel's memorandum to suggest that the Secretary, under the statute, had authority to put student borrowers in the same condition that they were in prior to the emergency, and that the nature of your argument is that that test is not met. Do you agree with the OLC's position and understanding of the statute, and how do you argue that it's exceeded that authority?
Your Honor, I disagree with most everything in the OLC opinion, but I agree with that part of the OLC opinion. I think it's right that that's what the phrase "no worse position" means. It means Congress was telling the Secretary he had the authority to keep borrowers near the status quo. But what we have here is a program that for 20 million borrowers is going to leave them without a single outstanding loan. That goes well beyond putting them back in the status quo ante. And for the other approximately 20 million borrowers that stand to benefit from this, their average debt is going to go from $29,000 to $13,000. Again, far beyond returning to the status quo ante.
And I understand the Secretary has considerable expertise when it comes to educational affairs. But in terms of macroeconomic policy, do we normally assume that every Secretary, Cabinet member, as learned as they are, has that kind of knowledge?
No, we don't. When we're dealing with a nearly $500 billion loan cancellation program, this is squarely in the ken of Congress. Congress has the power and expertise to weigh the balancing competing fiscal implications, particularly at that scale. So this is something that's outside the Secretary's expertise.
Justice Gorsuch?
I just wanted to make sure I understood your position with respect to some of the gnarly language in this statute, which is waive or modify affected individuals to ensure they're not placed in a worse position financially because of the COVID crisis. You'd agree that doesn't authorize the Secretary to place persons in a better position than they were because of the COVID crisis?
So I agree that the purpose is to ensure that they're not worse off, but I would disagree insofar as it's clear that he can provide class-wide relief. So if it turns out at the end of the day that some individuals are getting relief who it turns out wouldn't have needed it, Congress tolerated that and in fact encouraged the Secretary to err on the side of over-inclusion.
So you read this statute as not just authorizing the Secretary to place people in the same position that they were prior to an emergency, but to allow the Secretary to place persons in a better position than they were prior to the emergency?
No, I'm sorry. Let me try to clarify. His purpose has to be to ensure that they're not left worse off.
But his effect can be.
If the effect is that some individuals in the class receive relief who wouldn't otherwise need it, that doesn't mean that his plan is invalid. But if I could respond to your question about better off, worse off.
Let me just, I'm sorry, let me pose a different question. So some persons can be better off, is your position. I guess how many is my next question, right? Let's say two people in Missouri, okay. All right, they're better off, fine. But what if it's 90% of the class, just hypothetically? Could the Secretary do that under this statute?
So I think the right way to analyze that would be under arbitrary and capricious review, because as I've just explained, we think the statute tolerates some overbreadth. And so at that point, you would want to look at the Secretary's justification for his action. It sounds to me like that could be unreasonable, that maybe he wouldn't be able to justify that particular line drawing choice because it would be so extensive relief that isn't actually necessary. But one of the things you'd want to look at is whether there was a way to tailor it, whether there was a way to segregate the people who actually needed the relief or not.
I understand that.
And just in case you think this plan does that, Justice Gorsuch,
No.
it does not.
I'm asking a hypothetical, and I understand your point. You direct us to arbitrary and capricious review. With respect to the fairness question that the Chief Justice posed, would you direct us as well to maybe State Farm, for example, where the Secretary has to weigh not just the benefits to the persons he's acting to favor, but also the cost to others?
I think that is a more natural way to analyze those issues. I should emphasize, because we're in this case, that these individual borrowers didn't raise a State Farm argument. So they're not making these fairness allegations.
I hear you, but you'd agree that that would be a relevant consideration at some stage in a court's analysis of the Secretary's action.
I don't think that the Secretary could be faulted for not considering the interests of non-student loan borrowers, because I don't think that's one of the relevant interests that Congress expected him to take into account under this authority. As we've been
So
discussing
no,
laws all the time.
It's just irrelevant.
Yes, I think that his charge under the HEROES Act is to determine whether student loan borrowers need this relief.
Thank you, that's clarifying, thank you.